Aloha, and welcome to E Hana Kako, a weekly program on the Think Tech Hawaii Broadcast Network. I'm Keli'i Akina, president of Grassroot Institute, and I want to welcome you, whether you are somewhere across the world from Hawaii or you're here in Honolulu. We're broadcasting live from the studios at Pioneer Plaza, a place where monarchy has actually sat and talked and enjoyed conversation the way we are today. I hope you're having a good week, and we're here every week once again, and you can see programs on thinktechhawaii.com. My guest today will help us talk about the concept of defending liberty. Defending liberty is what organizations like the Cato Institute and the Grassroot Institute of Hawaii do. We do it in many ways. We get involved in researching issues that are important to public policy, government, the economy, society. We also get involved in presenting amicus briefs at important court cases and so forth. Today, I'm privileged to have an important constitutional scholar here in the United States and somebody who's been active in the work of liberty. Ilya Shapiro. Ilya is a senior fellow at the Cato Institute and the publisher, or the general publisher of I think I've got the wrong title there, the editor-in-chief of one of the leading reviews of the Supreme Court. He's an expert in his field, but more than that, he's passionate about making a difference in the world, about defending liberty. And so we welcome him to the show today, both as a senior fellow at Cato Institute and also as a scholar at Grassroot Institute. He's one of our consultants. You'll see some of his writings on our website. We use his expertise in meetings here in Honolulu. And of course, Ilya gets to enjoy the beautiful weather here. Ilya, welcome back to Hawaii.
Good to be here.
Well, you know, you've been here in Hawaii many times, actually. What do you like most about our island paradise?
Well, you fly in and you feel the spirit of Aloha. It's always a working vacation for me when I'm here. Probably more emphasis on the work than on the vacation, but it's nice to wake up in the morning, even when you're jet lagged, and take a run on the beach.
Do you have difficulty telling your colleagues that you're actually working here in Honolulu?
Some of them don't believe me, and some think that it's some ridiculous boondoggle, but thank you for putting together such a busy schedule that I can forward to my bosses and show them, look, I probably do more stuff this week when I'm here than when I'm surfing the internet in my office.
Well, you know, folks, that's true. Ilya is here working indeed every day, several meetings a day, meeting legislators, lawyers, law school students, speaking to educators and others, because what he does, defending the Constitution of the United States, has far-reaching application in terms of the quality of life here in Hawaii in every field and all throughout the nation. Let me ask you this question. When you were a little boy growing up, did you say to yourself, I want to work for a research institute, policy think tank, and be a constitutional lawyer? When did that become your calling in life?
You know, perhaps surprisingly, I didn't have that terminology in mind, but the sorts of things that I'm doing now, I've always been interested in doing, in the sense that I've always been interested in law and politics and public affairs, and writing and speaking and being involved in the world, trying to affect change in a way that I can believe in. And the Cato Institute, where I am in Washington, is the nation's premier libertarian, pro-liberty think tank, research institute. It's like a university without students. And we work a lot with smaller think tanks in the various states around the country. Each state has at least one free market-oriented, liberty-oriented think tank like Grassroot is here in Hawaii. And I enjoy interacting with our counterparts at these places, and I enjoy interacting with my colleagues that work on a whole variety of policy areas. As a constitutional lawyer, I get cases, or I talk about cases that involve healthcare or education or immigration or tax policy. I'm not an expert on these policy areas, but I talk to my colleagues who are, and that way I can translate their expertise into stronger constitutional arguments to defend the Constitution, which defends our liberties.
You know, you mentioned a word, libertarian, and I want to make a clarification and ask you to define that term for our audience here, because a lot of times people hear the word and they think a political party, but I don't think you mean that at all when you talk about the kind of thought that takes place at our think tanks, Cato and the Grassroot Institute, as well as what we try to affect in public policy.
Right. I mean, we're not political activists of any sort, be it for the Libertarian Party or anyone else. We're a nonprofit research organization, and it would be against our tax status to even be involved in politics in that way. But libertarianism.
Now, you're answering as a lawyer.
Right. Well, this is by way of introduction to the idea that libertarian means, in the rest of the world, it means liberal. It means being against the government involvement in people's lives, so that they can plan their personal affairs, they can plan their business affairs without undue regulation or interference, or the government coming in and telling them what they can or cannot do, without very good reason. And so we promote policies on a whole host of areas that allow people to live their lives, to pursue their freedom, as the Declaration of Independence says, to pursue their happiness in the way that they want to define.
Isn't that something, the way words change meaning in context? Because you mentioned that in the rest of the world, people who think like us are considered liberal because the word liberal means freedom. But here in the United States, oftentimes the word liberal refers often to social policy positions. And so I think that being able to define what we stand for is helpful. One of the things that attracted me to Cato Institute and to Grassroots Institute are the values: individual liberty, free markets, limited accountable government. Let me ask you this question. What role does defending the Constitution, which is your job, what role does that have in defending liberties for everyone in this country?
Well, the Constitution is the world's premier libertarian document. I mean, it was literally revolutionary at the time, right? We fought a revolutionary war to gain independence, and then the Articles of Confederation wasn't good enough. It didn't protect liberty sufficiently. There were a lot of dysfunctionality there. So 10 years later, the framers put together the Constitution, which is there not just as a roadmap of, we have Congress and we have the Supreme Court and we have the President, and here's how they work and here are the qualifications, but ultimately all of those structural things, even before we had a Bill of Rights or anything else, were there to protect liberty, because that is the purpose of government. It's not there to govern or to execute authority. It's ultimately there to secure our rights and our liberties. And that's a very Enlightenment era, 17th, 18th, 19th century sort of conception. We've gotten away from that because a lot of people think that government is there to give us stuff.
Now,
but as Thomas Jefferson said, a government that's powerful enough to give you everything you want is powerful enough to take everything away.
When you talk about the government protecting the rights of the individual, you're talking about a value that we have articulated as limited accountable government. In other words, not talking about government in terms of whether it's big or small, but rather in terms of whether it's limited to its purpose. And you mentioned something. The purpose of government really isn't there to be running everything and so forth. It needs to be limited to the constitutional purposes. Well, what is the purpose of government according to the Constitution?
To secure our rights, to protect our rights against violation, well, first of all, by the federal government itself, and then after the Civil War, with the passage of the 13th, 14th, and 15th amendments, against violation by the states. So no longer can, if a state is infringing your freedom of speech or freedom of religion or economic liberties, property rights, you can sue in federal court because the U.S. Constitution protects your rights in that way. And it also delineates, divides up authority, power, governmental power, between three branches at the federal level, separation of powers, and also federalism between different levels of government. And again, that's not done just as an exercise in political theory to show how smart James Madison was or anything like that, or clever, but it's there to protect our liberties, because if you spread out, if you divide and separate that power, then there's less of a chance that individual liberty will be invaded. And so when people complain, for example, that Congress is gridlocked and not getting anything done, well, most of the time that means the system's working. The government isn't supposed to act unless it's really in everybody's interest. and the structure is set up in that way that the normal course of things is that people should be able to pursue their own lives, define their own pursuit of happiness as they will, with very limited governmental interference. We're not anarchists. The government should be there to police the rules of the game, provide a stable rule of law, the court system. If I hurt you or if I breach my contract with you, sure, I should be able to invoke the power of the government, the courts, to remedy that. But the government shouldn't be going into picking losers and winners and redistributing and things like that.
Now, you've talked about two structures within the Constitution that pretty much lay the architecture for the way we are to be as a government and as a people. The first was the separation of powers between the different branches of government, and that would be the executive branch, the legislative branch, and the judiciary, the separation of powers. The second aspect you mentioned was federalism. In other words, something that we sometimes don't think of today. When we think of federalism, we think of this giant federal government. But federalism actually refers to the fact that each of the states is somewhat autonomous and rules over its own jurisdiction, its own state. Power is reserved for the states here, and the federal government serves that purpose rather than the other way around. Now, how are we doing in both of these concepts? Let's go to the first one, the separation of powers. Flipping ahead from 1700s to the late 1700s to today, how do you assess the United States in terms of the balance of power?
It's gotten unbalanced. There's supposed to be, in the nature of the system, a dynamic competition between the branches, and naturally each branch tries to expand its own powers, but the others are supposed to be there to check and balance it. But for various reasons, and this isn't something that's happened overnight or just under this administration or this one and President Bush, it's not a recent phenomenon, there's been an aggregation of power in the executive, and there's been a shrinking of judicial power in the sense that the judiciary, the Supreme Court on down, is not checking government excess at either the state or federal level or by the executive or the legislative branches. So we saw just this week with the State of the Union address.
Well, I want to come back right after this break and ask you about that. And in particular, I want to ask Ilya Shapiro to weigh in on how the State of the Union address by President Obama affects or reveals the condition of the balance of power here in the United States. This is Keli'i Akina with the Grassroots Institute. My guest today on Ehana Kako is constitutional attorney Ilya Shapiro, senior fellow at the Cato Institute and grassroots scholar. We will be right back after this short message.
I'm Hong Jiang, host for Asia in Review on Tuesdays.
And I'm David Day, host for Asian Review on Thursdays. Both of us broadcast our respective shows at 4 p.m.
And my topics tend to deal with questions related to environment, culture, history, and sometimes human rights.
And my shows tend to be on international business, foreign policy, geopolitics, and national security. And you can watch our shows live on the ThinkTech website at thinktechhawaii.com.
And you can also watch us on YouTube or Olalo.
So come join us on Thursdays at 4 p.m. I'm David Day.
And on Tuesdays at 4 p.m., I'm Hong Jiang.
Aloha.
Aloha.
Aloha and welcome back to Ehana Kako. We're a weekly program on the Think Tech Hawaii Broadcast Network, and Ehana Kako means let's work together. It's what we say at the Grassroots Institute of Hawaii, bringing people together for a better economy, government, and society. A Grassroots Institute is part of a network called the State Policy Network, in which every state has a think tank that does research, bringing together some of the best scholars to deal with government, economy, and society issues. And we share this research, but we also are affiliated with some national organizations, and premier amongst them is the Cato Institute. I'm delighted today that we have with us a senior fellow from the Cato Institute, constitutional attorney Ilya Shapiro. And Ilya is doing work with us here in Hawaii to help educate policymakers, educators, and the general public on the importance of the Constitution of the United States in defending our liberties. Ilya, you're doing a great job, and appreciate all of your weighing into what's happening in Hawaii. But yesterday, when I came to pick you up, you were trying to catch the last few minutes of the State of the Union address by President Obama. What did you think of that in terms of the issue we were discussing, the separation of powers, the balance of power between the branches of government?
I mean, more broadly, this was an unusual address because these things are typically laundry lists of policies and things like that, and this was much more broader with general themes, few specifics. But in terms of what I'm focusing on, in terms of the balance of powers, the separation of powers, the constitutional protections for liberty, there are some disturbing things that the president said. I mean, for many years now, and especially in the run-up to the address, this administration has had the theme that if Congress won't act, we will. And the president keeps saying that he has a pen and he has a phone, and Congress is dysfunctional, and he will act as much as possible by himself to enact his various policies. And the devil is in the details of that. We don't know what exactly he plans to do. But there's no clause in the Constitution that says if there's a reform that's very important and Congress isn't acting on it, then the president gets to implement it himself. There's been a breathtaking growth in the power of the executive under President Obama and under President Bush, and in different areas. They use it in different ways.
Well, Ilya, how do you measure the growth of the power of the chief executive? I know recently when I was in China, China's chief executive increased his power by consolidating certain structures. And one of my colleagues at a university said, he's now becoming like Obama. It's kind of ironic. But in what way would you measure that claim that the United States presidency has increased in its relative power in relationship to the other branches?
Well, there's not that much quantitative necessarily measuring to be done. I suppose you could look at the exponential growth in the Federal Register, the book of regulations, not laws that Congress passes, but Congress delegates certain authorities to executive agencies, departments.
But they function like laws.
They function like, they do have the strength of law. They can be trumped by a law. Congress can certainly trump them, or they can be challenged in court as going beyond what Congress charged them with doing. But whether you're talking about the IRS, the tax authorities, or Health and Human Services, the Defense Department, the Pentagon, they all put together these regulations, and that's all within the executive branch.
How about executive action? What is referred to by using his pen?
Sure. The president certainly has the capacity to make executive orders. I mean, those can be as simple as telling his secretary, his personal secretary, how to order his files. It can be something like telling the Attorney General that these are our enforcement priorities about this type of law. It could be a sort of a memorandum that he writes and signs that has less legal effect even than a regulation that's issued by one of these executive agencies. But the president cannot rewrite the laws or suspend the laws. So when we see things like, for example, delays in the Affordable Care Act that are implemented because it's simply not working, or insurers or employers can't figure out what the regulation should be, and for policy or political reasons the president suspends either the employer mandate, for example, or certain tax provisions, or a whole host of things that he announces that you can keep your policy if you like it even though the insurers have suspended it, these sorts of things. That goes beyond presidential power. Indeed, one of the things that the colonists in the Revolutionary era, in the founding era, objected to in the Declaration of Independence was that the English monarchs, especially King George, would arbitrarily suspend laws. This is a huge power by the executive that in our system of government, under our Constitution, the executive doesn't have. And I would argue that this even goes beyond what President Bush was critiqued for doing. For example, he had these signing statements that said that he would not implement parts of laws that he considered to be unconstitutional.
Sure.
And in a sense, that's admirable. I mean, you don't want a president or any elected official to be taking any action that he thinks is unconstitutional. But President Obama isn't making these delays or exemptions or changing or rewriting the law in healthcare or other areas because he thinks it's unconstitutional. He thinks it's not working right, or it's politically not good for him, and that's troubling.
Sure. So you see that President Obama's use of executive action has actually shifted the balance of power between the branches. Let's shift to that other concept that you brought up, federalism, and that is the protection of the rights of the states to determine their own future, their own destiny, have their own autonomy apart from the federal government. Recently, and you mentioned the Affordable Care Act, this was imposed as a law upon all 50 states from the federal government. And here in Hawaii in particular, we have some metrics that we can look to. We can look to the fact that we had effectively 93% of the population covered by health insurance prior to the Affordable Care Act, prior to Obamacare. And now that has been affected. We've dropped below that now with a system that doesn't work well yet. And in some ways, this is a harm brought to a state by the federal government. At the very least, we're having imposed upon us something that we didn't need in the first place. Does this speak to the problem of losing the concept of federalism?
It does. And it's not necessarily a violation of the Constitution to have a bad federal policy, but the more that the federal government does things that it doesn't have the power or the constitutional authority to do, the more of a risk it is that it won't match the needs of the states. The reason why powers were split up under the Constitution, some enumerated powers, a set list of 17 in the Constitution. I carry this around in every suit pocket I own. And in fact, when I was married this past summer, we had special ones made up with our names and the date on the back. But anyhow, the federal government has a list of 17 powers that it has. Everything else is reserved to the states, and that's because the framers, I think, correctly judge that there are certain things that can only be done by the federal government. National defense, immigration policy. We don't want to have one set of green cards in Arizona, another one in Wisconsin, another one in Hawaii. That makes no sense. But most of it, like regulating business licenses, like marriage licenses, like crime, police, that's a proper state function. Education. The federal involvement in education, the Department of Education, is quite clearly unconstitutional. In the area of healthcare and Obamacare and its effect on Hawaii, first of all, it's hard to see how regulating healthcare is a national issue. Now, we're many decades removed from some important Supreme Court decisions in the 30s, 40s, and 50s that talked about healthcare or insurance being something that was interstate commerce, because one of the powers that the federal government has is to regulate interstate commerce. But even setting that aside, compelling states to do certain things and imposing on citizens to do certain things is problematic, and that's why there's a lot of lawsuits. The Supreme Court decided one a couple of years ago, but there are a host of lawsuits still relating to Obamacare, and they're typically, every time there's a major piece of federal legislation, it's a lawyer full employment act. We can see this for decades in the future.
Do you think federal entitlements and federal funding are used to entice states into surrendering their rights? For example, here in Hawaii, we depend to a large measure upon federal funding and seek it actively for education, for health care, for our roads, for many, many areas that are not mentioned at all in the Constitution of the United States. And living here in Hawaii, it's commonplace that our legislators, our congressional delegations, leaders of state agencies are constantly looking to the federal government for entitlement money, for grants and so forth. What's the relationship between that and the maintenance of our freedoms?
Well, first of all, my economic policy colleagues would tell you that that's a terribly inefficient way of doing any of these things, education, infrastructure, whatever the case may be. Why send all this money to Washington, process it, spend lots of bureaucratic time and money in processing it, and then send it back in some way? Why not just keep it here? But that's
you mean it's money they actually took from us,
right? I mean, it's not like there's some money that's growing on trees that you're asking for. You're asking for your own money back, or perhaps some of California's money, or you're redistributing among the states, or something like that. It's not some money that grows in Washington. I live in D.C. If there was money that grew on trees there, that would be fantastic. But it doesn't. But the larger problem here, I think, is that you're right. It's not necessarily an entitlement mentality. That might be a problem for individuals or legislators. But the idea that the money that comes from Washington has a lot of strings attached, and you're right. You're making a bargain, a devil's bargain. Every time you get more money from Washington, federal funds, you have more regulations and restrictions and control that you're giving up from the state to Washington. So I think there should be a lot more flexibilities, and states should be able to say, okay, we'll reject money for this particular program in this area or many areas, but that means that our people will be taxed less. Sure. That I think would give states much more flexibility than they do now.
So one of the concepts of federalism is to restore the relationship between the states and the federal government so that states themselves have autonomy over their education system, over their healthcare system. Even counties at that level have more autonomy. And so governance really goes back to we the people. Is that the basic concept?
Right. The Ninth Amendment of the Constitution says that the listing of rights in the Bill of Rights in the Constitution aren't limited to those that are listed. There's others. Everything else is still retained by the people. The 10th Amendment says that the powers, however, that are listed that are given to the federal government are it. There are no more federal powers. Everything else, all other powers are retained by the states and the people. So we have popular sovereignty. It's not a matter of imposing states' rights or replacing tyranny of the federal government with 50 tyrannies of state governments. It's ultimately a matter of self-governance and we the people. And would we the people want Washington directing everything? Probably not. I mean, you would want Washington directing national defense. You would want Washington directing immigration, as I said. There's regulating interstate commerce. You don't want Hawaii taxing California and vice versa. But most of these things, whether it be education or healthcare or local transportation issues, these should be handled locally. And you're right, even further, sublocally or below the state level. School boards. There's a reason we have school boards rather than one big school board for each state, because Hawaii is a relatively smaller state, but even in Hawaii, the needs in Honolulu are different than the needs on Maui or on the Big Island. There are rural areas, there are urban areas, there are rich and poor, and each one should be flexible.
And what is that value of having smaller, closer to home boards for schools rather than one for an entire state? What is the value of that?
Well, there's more accountability. You have the government closer to the people, and the government that's more responsive to their needs rather than a one-size-fits-all solution.
And that's a constitutional principle of we the people.
Absolutely. It's all of the Constitution's structures that hopefully some of you viewers remember from grade school and high school and college and whatnot. Again, it's not just some dry thing, some manual for the operation of government. Ultimately is there to operationalize the idea that government is there to protect our liberties. And to the extent it's doing anything else, we shouldn't have it.
Ilya, we've got a couple minutes before the break, but I would love it if you'd summarize this nice little article you wrote. It's a list regarding the current president. What was the title of that?
President Obama's top 10 constitutional violations of 2013.
Yeah, give us a quick summary.
I wrote this in Forbes.com. 5 of them, I limited myself to 5, have to do with the Affordable Care Act. These sorts of, as I said, executive actions. Obamacare, for example, requires congressmen and their staffs to be subject to the state exchanges and things like that. Obamacare waived that unilaterally. I mean, there's a whole host of issues, delays, exemptions, so forth. Immigration reform. I'm for reforming our immigration policies, which I think are broken and don't serve anyone. President Obama did that unilaterally when Congress failed to act, for example, by allowing or giving green cards to kids who were taken here to this country illegally by their parents. I think those kids should be allowed to stay and work and join the Army and whatever they want to do, go to college. But the president can't do that by himself. That takes legislation. I hope Congress acts on that. There's a host of areas. Arguments made to the Supreme Court. This president has lost at the Supreme Court unanimously at a rate 3 to 4 times greater than Bush and 2 to 3 times greater than Clinton. Unanimously. I'm not talking losing some close liberal conservative votes, but unanimously. And so there's a lot of excesses here, and this isn't even without getting into issues of whether Obamacare itself, as written by Congress, violates the Constitution, but actions taken by the administration or the president himself.
You've built a pretty strong case then that the balance of powers has been damaged within this one presidency. Is it something that has been happening over a period of time under multiple presidents of more than one party?
Absolutely. This is not something that's just about Barack Obama or the Democratic Party. And I think the judiciary is as much to blame or more than anyone, because starting in the 30s, they started letting Congress and the executive get away with it. Before then, they would strike down laws, they would exercise their power of checks and balances, of judicial review, and now they just defer. They defer to Congress, they defer to the executive, and in turn, Congress says, we'll pass the law, we'll let the courts figure it out whether it's constitutional or not. So you have this vicious circle of deference, and who loses? The people and our individual liberties.
So we're experiencing something in terms of executive power that the framing founders of our Constitution had never imagined, or actually they had imagined it. They actually set up a system to prevent it. So how did that system get overridden in 200 years? How did this balance that is supposed to be a competitive balance between executive, legislative, and judicial get imbalanced?
In 1937, and for several years after that, the Supreme Court started changing what it was doing. And rather than strike down the New Deal era laws of President Franklin Delano Roosevelt, they started upholding them because we were in a depression, it was a good idea, whatever the case may be. And away we went. And the federal government all of a sudden started legislating in a whole host of ways. The Interstate Commerce Clause is one of the primary parts on which the federal government hung its hat. Well, everything affects interstate commerce. If I buy a Starbucks coffee at the corner store, you add all that up of everybody buying Starbucks across the country, and all of a sudden you have the federal government regulating local stores, which is not what the framers intended. They absolutely had all the prevention of this sort of thing in mind.
So we really need to have a vigorous exercise of the roles of the judiciary and of Congress and of the executive in competition with each other in order to maintain that balance. We're talking with Ilya Shapiro, noted constitutional scholar, senior fellow at the Cato Institute and scholar at Grassroot Institute. When we come back from this break, I'm going to ask Ilya to share a little bit of insight into some issues that he's worked with us on here in the state of Hawaii. I'm Keli'i Akina with the Grassroot Institute, wanting to say thank you to Think Tech Hawaii Broadcast Network, especially Jay Fidel, producer and grand poobah of everything that we do. Aloha, we'll be right back. Come back for our final segment.
Aloha. I'm Nicole Horry with the Think Tech Commentary. The PUC has established an investigative docket to determine the advisability of an undersea cable connecting the Oahu and Maui electrical grids. It has scheduled public meetings on both Oahu and Maui to invite comments on the proposal. The PUC is investigating whether a transmission cable between the two islands is in the public interest and whether the benefits to ratepayers would exceed the costs of the cable, which DBET estimates would be $700 million. The PUC also wants to know about development risks and how they would be mitigated. With the remarkable increase in PV in the islands and the availability of new grid technologies, it may be possible for each island to generate renewables that meet its own demand, and to have separate renewable grids for each island instead. At the same time, an island that depends heavily on a source of renewables, such as PV, may be vulnerable to local changes in the weather or an unanticipated problem with that single method of energy generation. The ultimate question for the PUC, then, is not simply whether an undersea cable is good for Hawaii, but how we can achieve layered redundancy for a resilient statewide system. ThinkTech believes that a great state needs ample power distribution, and that the proper approach is to start with this undersea cable, not only to bring the separate island grids and the state together, but as part of a strategy to achieve the security and safety of redundant systems. I'm Nicole Horry with this ThinkTech Commentary. Mahalo.
Welcome back to Ehana Kako. Our program this week is called Defending Liberty, and we've been talking with Ilya Shapiro, noted constitutional attorney, senior fellow at Cato Institute, about the importance of the United States Constitution in ensuring the liberties that men and women have fought and died for so that we can actually live a free life a liberal life here in the United States of America and at peace in the world. There are some thorny issues involved here, one of which is the balance of power between the branches of the federal government, as well as the appropriate relationship between the federal government and the states. But an important role has to be played by the judiciary. So I want to ask Ilya a question about our judiciary. Ilya, there's a term that many of us have heard called judicial activism. And it refers to the kind of role that judges see themselves playing when it comes to law and society. And you have some concerns about that.
The term judicial activism doesn't actually mean anything other than that the speaker doesn't like the case that he's talking about.
Okay.
The ruling that he's talking about. You know, liberals invoke it, conservatives invoke it whenever they're criticizing Supreme Court or other ruling that they don't like. They say, well, that's activist. What we want judges to be is restrained or passive. It's bizarre, because I think what we want judges to do is to interpret the law or interpret the Constitution and rule in the way that they see fit. Whether that means the law is upheld or struck down is of no moment, because we want unconstitutional laws to be struck down. We want constitutional ones or ones that comport with other federal laws to be upheld. And so whether you're talking about laws that conservatives like or liberals like, it doesn't matter. We want judges, if a particular law invades individual liberty in some way, if it censors political speech, if it prevents people from exercising their freedom of religion, if it gives too much power to police to invade your privacy, we want those laws struck down. If, on the other hand, there's a law that is within federal power or protects individual liberty, or there's no reason for striking it down under the Constitution, then we want the courts to let that go. And these go both ways. Liberals oftentimes talk about the activist Roberts Court for striking down, for example, in Citizens United, a campaign finance law, or more recently the Voting Rights Act case decision, Shelby County, just this past June. Well, if striking down laws is activist, then I guess liberals don't like Brown versus Board of Education, or Roe versus Wade, or Miranda versus Arizona. I mean, very important foundational cases. Well, and there are examples on the other side. So again, let's have a constitutional debate about your underlying theories of the law and what the Constitution's about, not about whether judges are activist or passive or what have you.
Well, all of us have observed congressional hearings in which nominees for judicial seats are grilled by a panel. And very often the questions have to do with issues, where they stand on this issue or that issue, and so forth. How relevant is that to the qualifying of a judge, particularly for the Supreme Court? And by the way, just a program note to those of you watching, as soon as Ilya answers this question, we're going to move to some of the input he's given us on some Hawaii issues. But going back to this for the qualification
it's
of
very
jurors,
important. And, if the Supreme Court, the U.S. Supreme Court hearings for the nominations to be new justices are a really big deal. You have all the media attention and the focus, and then you don't learn anything from watching this whole week-long hearings, because they try to say a lot and say nothing. But I don't blame senators for probing or having ideological litmus tests. I mean, if we imbue so much power to the federal government, and there's such a difference in view about what the role of the federal government is interpreting the Constitution is based on different people, then that certainly should be a consideration that senators have. But ultimately, we're not going to roll back the tide overnight. So it's a matter of bit by bit chipping away at these invasions of our individual liberty. And by the way, we've been talking mostly about structural concerns and problems with how the judiciary has been interpreting separation of powers or federalism or what have you, rather than, a lot of times people talk about the Bill of Rights or the 14th Amendment, due process, these sorts of things. Those are two sides of the same coin. It's not that there are, oftentimes conservatives only want to enforce the structural provisions, liberals only want to enforce the rights provisions. But they're there for the same purpose, to protect our individual liberty. If we didn't have the Bill of Rights at all, our constitutionally protected freedoms would be exactly the same. In fact, we didn't have a Bill of Rights for 2 years under the Constitution. And so I'm for enforcing the entire Constitution, whether that, some people say that means I'm a judicial supremacist, that I want to unbalance the balance of powers by giving too much power to the judiciary. I don't think that's the case. I think we need to rebalance because Congress and the federal and the executive have, over the decades, taken too much power for themselves.
You've been a consultant on some issues that have been important here in Hawaii. You've worked with the Grassroots Institute, you've done debates and so forth, and of course you're familiar with the Akaka Bill. Now that Senator Akaka has retired and Senator Inouye has passed away, the Akaka Bill is not going forward in Congress. At least the provisions of it are not going forward as a bill in Congress, although they're still lobbying for much of it. And I wanted to say this to our audience. The Akaka Bill has had many things about it that have been noble, such as a sense that we want to help the advancement of the Hawaiian people and all people, and I'm a part Native Hawaiian as well. In that sense, there are some sentiments about the Akaka Bill that are important here in Hawaii. But Grassroots Institute has focused in like a laser on one aspect of the Akaka Bill, and that is appealing to the federal government to establish a state-sponsored, race-based tribe or nation. From a constitutional point of view, Ilya, and you've done work on this for us, what's the problem with that? And once again, the Grassroots Institute is not opposed to the advancement of the Hawaiian people or even the self-determinism of any people whatsoever. But the idea of a race-based, state-sponsored tribal nation, what's the constitutional perspective, Ilya?
The constitutional perspective is that the 14th and 15th Amendments prohibit government action that's based on race. And nothing could be worse than designating certain people based on their race, based on, I don't know, one drop like the Nuremberg laws in Nazi Germany, or whether it be have to have some sort of blood quantum. Well, what about people living on the islands versus off the islands? It would be a tremendous problem of administration. But at the constitutional level, it offends the Constitution. And moreover, Hawaii is unique. The kind of racial intermixing that has happened historically, going back to the early days of the arrival of the Western and East Asian merchants and missionaries and what have you. It's the most interracial state there is. And this spirit of Aloha is being threatened by appeals to racial determinism. If something like this were to go through, then what's to stop Chinatown in San Francisco or New York, or the Jewish communities that are concentrated on Long Island or other places from demanding their own racial enclaves? And I must say that this is separate, a different discussion from Indian law.
And why is that? That's an important clarification to make, because many people say the situation of the Hawaiian political nation is similar to Indian law.
Congress can't create Indian tribes out of whole cloth. Indian law itself is somewhat problematic because there is a bit of a racial component to it, but it's more political actually. Indian tribes, sovereign tribes, predated the Constitution. They existed before the United States did. And so Indian law and the idea of tribal recognition or kind of a separate sovereignty is an accommodation of that pre-constitutional reality. And to get recognized as an Indian tribe, a group that wants to come under the auspices of Indian law has to prove that they have a continuous claim of political self-governance, that they were always an isolated, homogeneous people that govern themselves. It's a political consideration. Some of it has racial aspects, inevitably people that live together,
Right.
or an ethnic component. But in Hawaii, that would be very hard because, who is a native Hawaiian exactly? Again, the level of interracial cooperation and mixing here has been incredible, and there is no continuous political self-governance.
Sure.
You have to go back even before the monarchy, before the annexation, hundreds of years before that. Do you go to try to track to where your bloodlines left before Captain Cook in the 1770s or something like that? So it doesn't quite fit Indian law. It's people refer to the Akaka Tribe or the Native Hawaiian Tribe. That's not quite a thing.
In fact, it's well documented that the political citizenry of the Hawaiian Islands from the time of King Kamehameha I on was not based upon race. It included people of all races who were qualified to become citizens. But let's go back to our earlier discussion about the relationship between the states and the federal government in light of this issue, because in the setting aside of the Akaka Bill as a piece of legislation to go through Congress, other avenues have been pursued by activists, one of which has been to appeal to the President of the United States to use his executive action to call this Akaka Tribe, this tribe from the Akaka Bill, into existence with a, quote, government-to-government relationship between the United States and this tribal entity. Constitutionally, what are your thoughts about that?
Well, the Bureau of Indian Affairs, which is part of the Department of the Interior, certainly has the power to recognize Indian tribes or regulate how Indian tribes recognize members, that sort of thing, and then regulate the relationships between those tribal sovereigns and the U.S. government. What they don't have the power to do, what the Bureau of Indian Affairs, which is part of the executive branch, ultimately answering to the president, doesn't have the power to do is to create legislation. And to create an Akaka tribe under the Bureau of Indian Affairs would require a different type of act, because again, under no reading of existing Indian law, which is, as I said, a compromise with pre-constitutional realities, for the reasons that we've just gone into, can Native Hawaiians, at least as the Akaka movement, bill movement has defined them, be recognized
Sure.
in that way. So there would be a tremendous legal challenge. And as we saw the last time that the Supreme Court took a Hawaii case, Aloha versus Hawaii, about the ceded lands in Maui and so forth, the Supreme Court of Hawaii was unanimously reversed,
Sure.
because again, it just doesn't work in that way.
Sure. So we've been talking about the idea of a state-sponsored race-based nation. And once again, I want to clarify that we're not talking about whether Hawaiians can be self-determining or whether they can organize together or start a Native Hawaiian corporation like the Alaskan Native Corporation. But we're talking about the state itself sponsoring a race-based nation. And as we've just discussed, that has failed in Congress in over a decade. And that would be greatly challenged if the President of the United States used executive action. But there's a third route that has been tried here in Hawaii, and that is that our state legislature has passed law. In the 2011 session, the state legislature passed the Native Hawaiian Roll Commission Act, Act 195, that established a commission that would identify a citizenship role for the purpose of the state-sponsored race-based nation. And recently, we had a trustee of the Office of Hawaiian Affairs, and the OHA oversees this, on our program here, indicating that the program has been a failure. And not only that, he said that most Hawaiians don't want that kind of political organization, and that the money should be better spent in building educational opportunity, economic opportunity. But constitutionally, what is your thought about a state having an act to establish such a roll commission?
Well, I'm not sure what this role is for. At least it could not be operative until and unless there is some sort of separate race-based government, because the Supreme Court has ruled in Rice versus Cayetano, now almost 15 years old, that decision, that you can't have racial qualifications for elections. In that case, it was to elect OHA officials. And so this role, I guess it's to establish facts on the ground for an eventual, if there was ever this race-based sovereign and that was created in some way. But you're right. I think the money spent on that would be much better spent on schools and other projects to help those Native Hawaiians much more than these appeals to racial solidarity. And indeed, the resolution, the Treaty of Statehood, that when Hawaii joined in 1959, gave the state of Hawaii sovereignty over the former royal sovereign lands under certain conditions. That protecting Native Hawaiians is one of them, but also making sure that the lands are used for the benefit of all, and all of these other considerations, education, what have you,
utilities, farming, for everyone.
Exactly, agriculture, all of that sort of thing. And so this Akaka Bill style racial appeal, I think, is the tail that wags the dog of what's really best for the citizens of Hawaii. But again, this is a matter best left to Hawaiians, and I don't think there's ever been a referendum on the Akaka Bill or creating such a race-based government. I'm sure that its sponsors have never had one because they know that it would fail.
Well, you know that at Cato Institute and at Grassroots Institute of Hawaii, we advocate for the rights of all people who live here in the United States. And that would include the rights of any group of people, whether it be the Hawaiians or however else people conceive of themselves or whatever heritage they have. And so we have been very much opposed to the features of these laws that would put any barrier between the people and their Bill of Rights. And one of those barriers could be a tribal governance based upon this kind of law. And let's just close with that, because we've been talking about defending liberty based on the Constitution. So the Constitution of the United States.
I'm a double immigrant. I was born in Russia. We came to Canada when I was little. I was naturalized there. Now I actually have my naturalization papers. I've had my green card for 5 years. That was really hard to get. That's a separate story. But I have my naturalization papers in. I'm going to be one of these rare people that, knock on wood, naturalizes twice. But like most immigrants, I do a job that Americans won't, defending the Constitution.
There you go. And I'm so glad you do.
And that's partly why I feel so at home here, because this place welcomes people from all over the place. The history of Hawaii is just fascinating, and it's heartwarming.
Well, Ilya Shapiro, Big Brother Cato Institute, not Big Brother government, but Grassroots Institute's big brother out there in terms of the think tanks. Thanks for being one of our scholars, and thanks for working with us for liberty in Hawaii.
My pleasure.
We've been with Ilya Shapiro, constitutional attorney, senior fellow at the Cato Institute, talking about defending liberty. I'm Keli'i Akina, president of Grassroots Institute, saying mahalo to the ThinkTech Hawaii Broadcast Network. We'll see you all back next week. Aloha.